The law of tort. Liability under Rylands v. Fletcher. Liability under Rylands v. Fletcher is a particular type of nuisance. It is a form of strict liability, in that the defendant may be liable in the absence of any negligent conduct on their part. Imposing liability without proof of negligence is controversial, and therefore a restrictive approach has been taken. The case of Rylands v. Fletcher concerned the construction of a reservoir on the defendant's land to power his water mill. The reservoir was on top of a disused mine. Water got into the mine and spread to a working mine owned by the claimant. This caused extensive damage to the claimant's land. The defendant was liable for the damage. Lord Cranworth, in the House of Lords, set the requirements for liability to arise. These are: 1. Accumulation on the defendant's land. 2. A thing likely to do mischief if it escapes. 3. Escape from the defendant's land. 4. A non-natural use of land. And 5. The damage must not be too remote. 1. Accumulation on the defendant's land. The defendant must bring the hazardous material onto his land and keep it there. If the thing is already on the land or is there naturally, no liability will arise under Rylands v. Fletcher. This was seen in Giles v. Walker, where the defendant was not liable for the thistle seeds which blew onto his neighbor's land and damaged the crops, because the defendant had not brought them onto the land. Similarly, the rocks in Pontardawe RDC v. Moore Gwyn were naturally occurring and the defendant had not brought them onto the land. The thing that escapes need not be the thing that is accumulated. In Miles v. Forest Rock Granite, the thing accumulated was explosives. This caused the rocks to escape. The defendant was liable even though he had not brought the rocks onto his land. 2. A thing likely to do mischief if it escapes. The thing need not be inherently hazardous. It need only be a thing likely to cause damage if it escapes. In Hale v. Jennings, the defendant was liable when a chair from a chair-o-plane fairground ride broke free and struck the claimant. Similarly, in Schiffman v. the Grand Priory of St. John, the defendant was liable when the claimant was struck by a flagpole that fell from his land. 3. There must be an escape from the defendant's land. An injury inflicted by the accumulation of a hazardous substance on the land itself will not invoke liability under Rylands v. Fletcher. In Ponting v. Noakes, the defendant was not liable when the claimant's horse died, having reached over the fence onto the defendant's land to eat poisonous leaves. The leaves were all in the confines of the defendant's land. Similarly, in Reed v. Lyons, there was no escape when a factory worker was injured by an explosion in a munitions factory. 4. There must be a non-natural use of land. In Rickards v. Lothian, it was held that having washing facilities in a workspace was not a non-natural use of land. In Transco v. Stockport, Lord Bingham preferred to use the term ordinary and extraordinary use of land rather than non-natural. It was ordinary use of land to have a water supply to a block of flats. An open fire in a domestic fire grate does not constitute a non-natural use of land as seen in Sochaki v. Essays. 5. The damage must not be too remote. Liability in Rylands v. Fletcher is subject to the rules on remoteness of damage. This point was established in Cambridge Water v. Eastern Counties Leather, where it was not foreseeable the water supply would become contaminated as a result of spills of chemicals on the factory floor. The wagon mound test applies, that is, was the damage of a type or kind that was foreseeable. Weller v. Foot and Mouth Disease Research Institute established there is no liability for economic loss under Rylands v. Fletcher. Special defenses applicable to liability under Rylands v. Fletcher. 1. Act of stranger. If the escape was caused by the act of a stranger over which the defendant has no control, the defendant will escape liability. In Box v. Jubb, the defendant was not liable as he had no control over the actions of the owner of neighboring land who had drained his reservoir into the defendant's, causing it to flood. Similarly, in Perry v. Kendricks Transport Limited, the defendant was not liable for the acts of the boys throwing a lighted match into the petrol tank of the bus on their land. If, however, the act which caused the escape was committed by a person over whom the defendant may exercise some control, the defendant may still be liable. This was seen in Ribby v. Norrie, where the landlord had the right to ban smoking in the premises, but hadn't done so. 2. Wrongful act of a third party. the defendant will not be liable for the wrongful act of a third party. In Rickards v. Lothian, the defendant was not liable for the acts of vandals that caused a flood. 3. Act of God. The defendant is not liable for hazards naturally occurring. In Carstairs v. Taylor, the defendant was not liable for the acts of a rat in gnawing through the drain and the heavy rainstorms. 4. Statutory authority. In Green v. Chelsea Waterworks Company, a water main burst causing damage to the claimant's land. Chelsea Waterworks Company were under a statutory obligation to maintain high pressure in the water main. This would mean that any escape would inevitably cause damage. They were not liable as they had the defense of statutory authority. 5. Consent, benefit. If the claimant receives a benefit from the thing accumulated, they may be deemed to have consented to the accumulation. In Peters v. Prince of Wales Theatre, the claimant's shop suffered water damage from the defendant's sprinkler system. It was held that they had consented to the sprinkler system since they would benefit from it. The defendant was not liable. In summary, Rylands v. Fletcher imposes a form of strict liability. For liability to arise, the defendant must accumulate a thing on their land which is likely to cause mischief if it escapes. There must be an escape which causes damage, and the damage must not be too remote. In addition to the general defenses in tort law, there is also act of third party, act of God, and statutory authority and consent or benefit. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.